Are you aware that some of the schools that are most famous for their legal writing programs are sort of in the middle to bottom tier of law schools, and that the top tier law schools tend not to focus on it a great deal?
Right.
Is that just because the students are probably coming in as better writers?
No, I think it's probably because they think that their students, they kind of have this idea of their students as better writers, but I'm not sure it's a true idea. So I think that all schools really ought to, be thinking about this in a pretty deep way, because, to be a good lawyer, for the most part, not all lawyers have to be great writers, but most lawyers, they're going to do their jobs a lot better if they're great writers than if they're terrible writers. And as I say, at the Harvards and the Yales and the Stanfords of the world, you can find lots of students whose writing can be improved.
Are you doing much extracurricular writing these days?
I write my opinions here, and is the question whether I'm writing a book? Is that the question?
Well, what about an autobiography?
Yeah, no, I don't think so. I don't have a very good story to tell, I don't think. Or else maybe I'm just not interested enough in writing about myself.
You've had publishers approach you, though, undoubtedly.
Well, sure. I think probably all of us have had publishers approach us, but that doesn't necessarily mean that you have a great autobiography in you. I admire my colleagues who have written autobiographies. I think some of them are absolutely fantastic, but I guess I don't see myself adding to the list.
Do you have any linguistic pet peeves? For example, Justice Kennedy cannot stand the word impact as a verb.
Uh-huh.
That impacts how we view this.
Yeah, I don't use that one either.
Justice Scalia hates citing to a case as opposed to citing
a case.
Yes.
Yeah, both of those strike me as right.
The objections strike
Yes,
me as right.
both of those, the objections strike me as right.
Mm-hmm. And what about you, though? Your linguistic pet peeve?
Oh, gosh. I don't know, maybe I don't spend quite, I don't know.
Is there something that an interviewee with you, a law clerk, prospective law clerk, in an interview might say that you'd say, no, I don't think so?
Just like the use of a word?
Well, for example, I'm not sure where it's at. Would that bother you?
No.
It wouldn't?
No. Why? Because it's too colloquial?
Well, it used to be considered uneducated speech, that you just say where it is, not where it's at. But the problem is not ending with a preposition, it's just the redundancy of where and at. But do you not have any...
I like to think that I wouldn't be judged on the basis of a single sentence that I say here in this interview or anywhere else.
Well, you're unusually eloquent. I think people know that. So do you notice mispronunciations, for example, in court?
I guess I notice them, but, I try hard not to hold those things against people. I think, it's funny because impact is a verb. I would never use impact as a verb. So I have my own rules for what I think you shouldn't do, but the fact that somebody else might have different rules, that's I don't think that that's the measure of what a good lawyer or a good advocate is.
Do law clerks do a lot of reading and suggested edits on opinions?
For me?
Yes.
Yes. So I have a very long, extensive writing process. It actually starts for me when I get a draft of an opinion from a clerk. I've tried doing opinions without a draft from a clerk, but I actually prefer, although I'm not going to use anything that the clerk writes, I actually prefer to see a draft done by another person. It helps me start thinking about the arguments. It helps me start thinking about the right way to organize an opinion. It just gives me a kind of springboard to think about a case, to see how another person writes it down. So what I'll do is I'll come back when I have an assignment. I'll talk to the clerk. I'll say, of course, here's what the disposition is. They'll know that already. And I'll tell the clerk, what I think the main points ought to be. And then I'll ask the clerk to do an outline for me, and I'll stare at an outline for a while, and we'll go back and forth on an outline. And then once we're at the, once we have both sort of looked at the outline a bunch of times, I'll say, okay, now go back and write a draft. And they'll come back and produce a draft for me. And then I'll sit there and I'll think hard about that draft. What are the points I like? What are the points I don't like? Why? Which arguments are working for me? Which arguments aren't? So that I'll use that to just all, but for me, I don't really understand any case until I write it. So I'll start a new document and write it straight through for myself. I'll have the clerk's draft on another screen. I'll drag over sites. Every once in a while, I'll see a line that I like. But mostly, I'll produce a document that I would say is about 98% mine. Mm-hmm. The draft helps me do that, but the new opinion is me. It's in my voice, and it's the way I think through a case. It's the way, I guess for me, it's really important to do that for two reasons. Even when I've had clerks who are great writers, they're not me. They don't sound like me, they sound like them. And also, I see things about a case that I would never see if I were just editing somebody else's work. I see things often when I'm really, going sentence by sentence by sentence, paragraph by paragraph. It will raise questions that I didn't know were questions. It will cause me to think of counter-arguments that I wouldn't have thought of otherwise. So for me, the writing is very important. But then when I get to the end of a draft, it's just the end of a first draft. And my first drafts are just first drafts. They're not final products. They're pretty, they're written, they're not sketchy. There's not a lot of like fill in this or fill in that. I basically write a complete draft. But at least for me, my first draft is not the end of the game. I'll give it back to my clerk, and I'll say, edit it. And one of the hardest things for one of my clerks, but something that they have to get used to very fast, is to really come back at a Supreme Court justice and tell me everything that's wrong with something. Here are the big picture points, the organizational points, the small substantive points, and lots of style points, and I want it all. And they have to get comfortable really coming back at me and saying, I would change this, I would change that, I would change the other thing. And I'll take that edit and I'll take as much as I want. I'll use my document as the starting place, but I'll change a lot. Sometimes I'll just change things in accord with what they say, but sometimes, I sort of look at what they say and I think, I understand the problem, I don't really like their solution, we'll come up with something else. And then it goes back and my other three clerks do the same thing. They do it all, so I get one edit for one clerk, and then I get one edit, which is a composite of three other people who know the case a little bit less well, who are reading it a little bit more as outsiders would, and as people who aren't like steeped in everything, which I think is a good thing. And then I'll do it again. And by the end of that 2-round process, my draft will look, pretty different from the draft that I gave to the clerk. And then we'll do a little bit more minor stuff back and forth, just getting some of the style stuff right. But that's the basic process I use.
Might it go through 10 drafts?
No. I know that there are some judges who do this kind of, 10 draft, or, Judge Kaczynski is
70,
famous for doing,
70,
right?
yeah.
I almost don't exactly know what that means. For me, I do 2 really intensive drafts where a lot changes. And for me, that takes long enough so that I'm not sure I could do any more, and that by that time I'm pretty comfortable with what's there.
When you write, do you have a particular reader in mind? Are you just writing for the public, or are you writing for your aunt or uncle, or do you have somebody in mind that you're writing for?
Yeah, I don't have a particular reader in mind, but I guess I would say I have a type of reader in mind. That what I try to do is to write so that a non-lawyer can understand it, but not any non-lawyer. I don't want to dumb it down too much, you know, and I don't want to explain things that really don't need to be explained. So I guess I have in mind, you know, the reader of the New Yorker or something like that. You know, a person who is a reader, who, you know, maybe of some education or of some intelligence or whatever. I don't force myself to write so that anybody would be able to understand it. I think that, as I said, would just dumb down things too much. But you know, I try to write so that people who are used to reading, people even if not law, will be able to follow what I'm doing.
Let's talk a little bit about, we don't have a lot of time left, but decision-making and stare decisis and legal education. Do you think that law schools are doing a good enough job in helping students understand the difference between dicta and holdings? Do lawyers very often bring up before you, Your Honor, that was dictum, that's not a holding, that sort of discussion? And just do you think that that distinction is as important as it once perhaps was?
I guess of all the things I think that law schools might do better, that's not one that I would put high on the list. I think that law students do come out of law school basically having a sense that there's the holding of a case and then there's a lot of stuff in the decision, in the opinion, that's not the holding, but that is supportive of the holding, that counts as dicta. And certainly when people argue the cases before us and when we decide cases, we have to think about that all the time. Was that part of the holding, or was it something that we can more readily ignore? Now, even dicta you can't ignore. You have to deal with it, but you don't have to deal with it at quite the same level. So, you know, I guess I basically think that law students are instructed in that and that legal advocates have a sense of that. Obviously, they're arguing cases, and somebody's going to argue that this is a holding, and somebody's going to argue that no, it's not a holding, it's just dicta, and that's their job. And then we have to figure it out.
Is stare decisis more important in cases involving statutory construction than it is in constitutional law?
Yes. So I wrote an opinion this year about that subject. Kimball, yes. Which everybody just knows as the Spider-Man case.
Yes.
And I had a little bit of fun with it because I did have some Spider-Man references.
Did you have any trepidation about doing that?
No, I guess this comes back to the question of, you know, it is a majority opinion, and you know, I think some people would say that there's a certain kind of formality that goes along with that. And I think that this opinion did maybe come close to the line by doing a few superhero metaphors and references and puns. But I guess what I figure as to that is, you know, there's no rule against fun in Supreme Court decisions, and to the extent that anything was inappropriate or not respectful enough of the court or its processes, one of my colleagues will let me know. And in that case, nobody did. There was nothing that was left on the cutting room floor. I think people felt as though it was an opinion about a Spider-Man glove and, you know, web shooter, and it was sort of appropriate to have a few Spider-Man puns in there.
So, and back to the point of the substance of the Kimball opinion.
Yes, but the Kimball opinion is actually an important opinion. You know, what the Spider-Man puns make it a fun opinion, I think, but it's an important opinion because of what I say about stare decisis, or I hope it's an important opinion. At least it strikes me as you know, this is an opinion writing assignment where I really had an opportunity to lay out what I thought about stare decisis. And I take stare decisis extremely seriously, and especially in statutory cases, which this one was. And for me, that made a great deal of difference.